get to the big corporate story of the day. It's a battle that has been going on pretty much since 2016, and the next hearing of the battle between the Tata Group and the Mistries, that is the Shapoorji Pallonji Group, is slated for November 3rd. In the midst of this, on the eve of that very crucial hearing, the Shapoorji Pallonji Group this evening released its proposal, its plan for what a separation would look like. More importantly, they've officially filed an appeal for separation in the Supreme Court. Remember, several weeks ago, the SP Group had said that it wanted to separate from Tata Sons after the Supreme Court stopped it from pledging its shares in court. The Tatas had at that point said they were willing to buy the 18% stake of the SP Group in Tata Sons. Now this separation formula has come about, and that's where it gets really interesting. They want a pro rata share in all the listed companies of the Tata Group. They want a pro rata share in the brand valuation of the company based on what the Tata Group has already said publicly. And they want a third party, a neutral person or an entity to gauge their value in the unlisted entities. Now, they also look at their entire stake in Tata Sons at about 1,75,000 crore rupees. The question is, how will the Tata side respond? What will happen in court next? And what kind of a precedent does this case set? Not only is it India's biggest corporate battle, but it is also a very, very key one when it comes to minority shareholder rights and what the corporate law in this country says. So to speak on this, I'm joined today by Sanjay Asher, Senior Partner at Crawford Bayley Co. Anil Singhvi, Founder and Chairman of Ican Investment Advisors, joins us on the show, as does Gupta, Founder and MD of Stakeholders Empowerment Services. Welcome to all of you, and thank you for speaking with us today. Mr. Singhvi, let me get your take first. How do you look at this? And of course, with the disclaimer that you are working with the SP Group on this case, isn't it?
Tamanna, let me address this issue by, not taking Tata Mystery battle as the focal point. Let me just make it very clear that ultimately this matter is now with Supreme Court. Supreme Court, as you know, is the highest court, and whatever Supreme Court says becomes the law of the land. So in this case, Supreme Court has to really look at not the bickering or not what's going on for the last 4 years, that what should be the law and interpretation of the law for minority shareholders, because this will be setting the precedent for all the time to come of the minority shareholders protection. India, as you know, in next 10, 15, 20 years will be seeking a lot of external capital for its growth. And this capital will flow into India only if the minority rights are protected. So I think the courts today, according to me, the mandate is not to decide on Tata Mystery, but to decide on the law for the minority shareholders for all the time to come. Having said this, let me now dwell on the matter. I think the matter is very simple. When the Mystery family wanted to pledge the shares, Tata moved in the court and said that they can't pledge the shares. So if you own an asset which cannot be pledged or cannot be sold and it cannot be bought, what am I supposed to do with that asset? It can't be. I understand in a private company the shares are illiquid, but they cannot be just that not dealt with. So I think today, after having gone through this battle for 4 years, what SP Group is proposing is a very fair thing, that both sides should sit together and decide. And mind you, in the last hearing, the last word spoken in that hearing by Advocate Salve was this, that Tatas are prepared to buy the stakes. So what today Mystery family has really worked out on this, that if you are willing to buy the shares, because you've been objecting for every situation in which we are, please buy my shares. Now question will come, you can't deny that they can't buy the shares because you already admitted in the court, in the floor of the Supreme Court, this was stated that if Mysteries are interested, Tatas are willing to buy. Now question will come of the valuation. And I think there are enough pronouncements on that. So I don't think it is such a tricky matter. The issue will, before Supreme Court, will be how quickly they decide on the matter, because they can't be taking a long-drawn battle to take much longer period in deciding. Okay. It's a very, very simple case. No, let me just complete. It's a very simple case, and I think Supreme Court has to rise, because you cannot get to see that SP Group goes for liquidation, though they are owning 18% Tata Sons shares. So this is a very important factor, that you cannot drag your feet by making other party go completely bankrupt, because ultimately it's a reputational issue as well. You own 18% of one of the most valued company in the country, yet you are declared a defaulter by the lenders. That's a very precarious situation. The court has to rise to the occasion and provide an immediate relief in this matter.
You know, that's actually a very crucial point, that all of this is time bound in the sense of it's a race against time for the SP group. JN Gupta, how do you look at this? And when it comes to matters of corporate governance and rights of minority shareholders, do you think that that's one of the key points here, as Mr. Singhvi says? And what is your take on the proposal which has been put forward by the SP group?
Okay, you have asked so many questions in one question, so I will handle it one by one. The first is very clear that, as Mr. Singhvi said, that this decision should come as fast as possible. While agreeing with this, I would say every court battle should be decided as fast as possible, whether it is murder accused, whether it is a commercial dispute or something, because justice is justice. You can't say that this type of justice will be given in the 1 week, that type of justice will be given in 6 years or 10 years. So I would say, yes, the demand is that justice should be done fast, and in this case, it should be done because what SP group will lose out is very difficult to explain. What will be the position if they cannot pledge the share, if they cannot sell the share? So how much impact will be there? But such impact has to be examined in all cases, not only in this case. That is first part. The second part is, I very clearly agree that the minorities have to be protected. But then the concept of minority protection is that protection from what? If it is a protection from some sort of a minority oppression or something, yes, it should be done. But then this entire thing is a subject matter of dispute, whether there is an oppression or not. And unless that is decided, what are the minority right can also not be decided. But having said that, I would say that a minority should be given as much right as available to majority, not more, unless until there is a case of oppression. Otherwise, what you are going to do is this: you are going to create a situation where a small shareholder can blackmail the entire majority, and as we have seen in many cases, that very small number of shareholders can bulldoze the majority, which is not the concept of governance. Governance is fair to everybody. It cannot be fair to one part or other part. The other part is very simply, you ask me a question that what is the opinion on the proposal? I would say, in any dispute, if there are two parties, one party will want to get the best deal out of it for himself, and the other party will try to give the worst deal to the other person, depending upon the situation. That's why the matter has to go to the judge, a Supreme Court, which will see to it that it is done in a fair manner. Now, what is fair and what basis the judge will decide fairness, it will be dependent on how it goes. But I would say that if you read what is the situation, what Mr. Mistry family has asked, is something more of a distribution of asset. They have not asked for selling their shares. They have said that what is the underlying of the Tata Sons, it should be distributed. I don't think that is the case here, because that is, the Tatas have said that they are willing to buy the shares, buy the stake, but they have not said that they are ready to distribute the underlying asset between the shareholder. In that case, what will happen if I give distribution to one shareholder, I should be giving distribution to other shareholder. Of course, Mistry has written in very clearly in this that it will be good for the other Tata companies also, which will have liquidity. But that is the ploy that they are playing. So I would feel that the judgment should happen fast, but it will happen based on what is the established concept of fair value, how the fair value of a company like Tata Sons will be done. And there have been precedents all over the place how such valuation is to be done. Although I am not an expert on valuation, so I will not be able to tell you what value I will assign to it.
Yeah, let me get in the corporate lawyer's point of view. Mr. Sanjay Asher, how do you look at it in terms of, and a couple of things that I want you to come in on. One is, how crucial is the kind of precedent this case sets? Are there examples that can be followed while deciding on this case? And do you think that it's likely that the Supreme Court will get into the valuation battle?
Three questions. I would see this as a very good example in case of a dispute between minority shareholder and a majority shareholder for settlement of the dispute. And dispute, when it is settled, when both the parties are unsatisfied, is the best settlement. It can't be a win-win or I win. I mean, it has to be a win-win. It can't be I win, you lose situation. So, as far as the settlement is concerned, it will set a good precedent in respect of any dispute between a minority and a majority shareholder. Two, tribunal and the Supreme Court will have the power in order to determine as to how to settle the dispute. It may appoint a third-party valuer for the purpose of deciding the valuation rather than sitting in judgment itself as to what should be the value of the shares of Tata Sons. It may appoint an expert or it may appoint a panel of experts for the purpose of determining the value. And three, surely that the company or the Tata Group can acquire the shares of the SP Group. And in case the Tata Group may not want to acquire the shares, powers of the tribunal under 242 are wide enough to have a reduction of capital, and that reduction of capital can be settled through the settlement through in kind rather than for cash. So in other words, surely some of the assets of Tata Sons can be distributed towards the reduction of capital.
Okay, so a distribution of the underlying assets is very well on the table because otherwise there would be huge sums of cash to cough up at this time. Mr. Singhvi, give me a sense of, at least your take on what the ultimate purpose is for the SP Group. Right now, because of COVID-19 specifically, the priority has become to raise money either by pledging their stake or by selling it, and perhaps selling it to the Tata Group. Does that race against time put them in a slightly disadvantaged position in terms of negotiation? They need the money first and fast.
Well, Tamanna, I think you raised a very important question. I think for last 4 years, as I look at it dispassionately, SP Group has been put into a very disadvantageous position, no doubt about it. But now a stage has come where perhaps a truce is being called by them. They don't want to get into a very long, lengthy, litigious matter, asking for board seats, asking for many other rights as a minority shareholder, which I'm sure they can. But I think they want to settle the matter because last time the olive branch was shown by Tata Group in the court saying that we are willing to buy the shares. So when they're caught up with the situation that the shares cannot be pledged, the shares cannot be sold, I think the best thing is capital reduction, because Tata Sons obviously can't pay in cash. So it's much better that some assets are distributed. And definitely SP Group is running against the time, as I mentioned earlier also. They have a large borrowing, and you cannot have that on one side of the balance sheet of SP Group. You have such prime asset called Tata Sons shares. And on the other side, you have a liabilities, and the lenders to you are taking you to the cleaners. That's a very unfortunate situation. But as the case may be, today the matter is with Supreme Court, and I'm sure court will rise to the occasion, as I mentioned earlier, to decide in this matter quickly enough that whether the Tatas are willing to buy the shares, and if they're not willing to buy the shares for a variety of reasons, then according to me, the pledge and sale to a third party should also be allowed, because you can't be so restrictive that you won't buy the shares, but you won't allow the other party to even pledge the shares or sell the shares to a third party. I think the matter is now reaching to almost a final stage. Valuation is not such a big game because most of the Tata Sons shares are listed company shares. Whatever unlisted company shares are there, also can be really value can be arrived at. So I don't think it's a big rocket science to arrive at the valuations. I mean, day in day out, you see if the large corporations in India are buying the minority stake, the valuations are known. We are not sitting into that kind of judgment in an unlisted company that you have a very lengthy process to arrive at a valuation. So valuations is a expert subject, but it's not a complicated subject. It can be arrived in a couple of weeks. It's not going to take months and years on that. And secondly, SP Group has to be given an immediate relief in terms of providing some capital for them to discharge their debt. And I think Supreme Court, and I'm sure Tatas also would, or Tata Sons would also agree on that they can't have. I mean, whatever may have been the dispute, today it should come to an end. I think it is good for both sides. And according to me, it will be a very good thing for India Inc. as well, that such a prestigious company called Tata Sons should rise now to the occasion to settle this dispute amicably from both sides.
You know, in a sense, an exit route has been put in place, precipitated by COVID-19. Mr. Asher, do you see the Tata side taking this opportunity to close the matter completely? Because remember, this case first went to the Supreme Court as a challenge to the NCLT order in December last year.
They would take this opportunity to put a finality on the matter and close the dispute, for sure. And in the previous question, you asked me whether there are any precedent. For example, the schemes of demerger whereby the distribution of assets also happen. And the classic example which started around 35 years back was the DCM family, where again there were schemes of arrangement whereby the family members got the shares of the respective entities which they were wanting to control or wanting to manage. So there are sufficient number of precedents whereby through the reduction of capital, by distribution of the assets of the company to the minority shareholders, surely the court can interfere and bring a finality to the entire dispute. So to answer your question, yes, surely Tata Group will take this opportunity to close this issue and to put this dispute to an end and finality.
Well, will they, very quick last word from you, Mr. Gupta, do you think that they will accept this particular formula, the pro rata stake?
I am not a spokesman for Tata, so I don't know whether what they will accept, what they will reject. But I would agree with Mr. Singhvi that in case Tata do not buy the shares, they will have to accept that SP Group can sell those shares to some third party or pledge, because you can't take away the economic right to those shares from SP Group anymore. But the other thing is, it's very simple, as Mr. Singhvi said, that valuation is not a rocket science. But the problem is that what is value of Taj Mahal in my eyes and what is value of Taj Mahal in your eyes are two different things. And that is where the problem is likely to happen, because the perception of the valuation, because Mistry Group is valuing today the company based on sum of the parts method, which from Mistry Group is right. But when you have a holding company, there is a holding company discount. And if you have looked at last 100 valuation reports, always holding company discount is taken care of. So that will be a gap between the two sides, and whether it is resolved through the mediation process or through the court process or what the Supreme Court feels, I am not able to see, because I am not sitting in the judgment and I am not speaking on behalf of either SP or Tata Group.
Sure. You know, interestingly, there has been no headway or real mediation of any sort so far. There was ample opportunity for it, but the last statement from the Tata Group clearly said that they will respond to whatever it is only in court. So all eyes on that crucial hearing next week. Thank you so much to all of you for joining us on The Big Story this evening.